Good afternoon, everyone. My name is Cristina Ramirez, and I want to welcome you to the fourth event in this year's colloquium on reproductive justice, criminal law, and the carceral state. This colloquium is part of the Rappaport Center for Human Rights and Justice's Sissy Farenthold Reproductive Justice Defense Project that I'm a part of, along with the project director, Blake Grocap. I would like to begin by acknowledging that we are meeting on the indigenous lands of Turtle Island and acknowledge the American Indian and indigenous communities who have been or become a part of the lands we call Texas, including the Alabama Coshada, Caddo, Carrizo, Comocrudo, Coahuiltecan, Comanche, Kickapoo, Lipan Apache, Tonkawan, and Isleta del Sur Pueblo. The colloquium is also a part of an interdisciplinary seminar that Professor Karen Ingle, Blake Grocap, and myself co-teach at the law school. There are two and a half tables of students here today that have read and written papers and works that Professor Wendy Bach will present on today, and they will have a chance to answer a few of the first questions, but there will be time for everyone to engage. With that, it is my enormous pleasure to have with us today Wendy Bach, Professor of Law and co-director and co-founder of the Appalachian Justice Research Center at the University of Tennessee College of Law. Today, she will present Pregnancy as a Crime, a preliminary report on the first year after Dobbs, which documents the initial findings of a national research study tracking prosecutions for pregnancy-related conduct in the first year after the Supreme Court's decision in Dobbs. This study is a collaboration between Pregnancy Justice, the University of Tennessee College of Law, our own Reproductive Justice Defense Project here at Texas Law, and several other law schools across the country. We are proud to be a part of this research team. Professor Bach's research focuses on the intersection of poverty law, criminal law, social welfare provision, law and society, and community lawyering. Professor Bach is the author of numerous law review articles and the book Prosecuting Poverty, Criminalizing Care in 2022. Before entering the academy, she was the director of the Homelessness Outreach and Prevention Project at the Urban Justice Center in New York City and a staff attorney with the Legal Aid Society of Brooklyn. After Wendy speaks, we'll have the opportunity to hear a response from Professor Jennifer Lauren. She studies and writes about how law and institutional design shape the functioning of criminal justice institution, and her scholarship has considered the roles of constitutional litigation in regulating police, the shared roles of courts, police, and lawyers in regulating forensic science, and the oversight of indigent defense. So without further ado, Professor Wendy Bach.
Turn this thing on. Okay, so thank you, Christina. I just want to, as she said, we are part of a team together, something that is really an honor. We've been talking about having this visit for a while, so I'm really, really thrilled to be here today. Thanks to Karen and Blake and Christina and Jennifer for the invitation. Thanks to the students. I had a great lunch with your students already, and they wrote some really great reflection papers that we're going to talk about a little bit. So the report I'm going to talk about came out in late September. I'm up here talking about it, but it's the work of a lot of people. The co-author is Professor Madeline Wasilczyk at South Carolina, who I've collaborated with for many years and who co-authored the report. And then, this report, when you look at it, it's like, a bunch of data. It's all very clear. The amount of human beings and work that went into this is not just my work. I'm proud to lead this research team, but there are this lovely team in Texas, folks in South Carolina, Alabama, Oklahoma, and a really amazing young research staff at Pregnancy Justice who've been working on this study with me for another year, for about a year and a half, something like that. So I have a few goals today. I want to tell you about the study. This is a 3-year study seeking to track the prosecution of pregnancy-related crimes in the 3 years since the Dobbs decision. It has multiple layers and multiple goals, and we'll talk a little bit about this. But this is a preliminary report. It's our first report, and it's limited in really important ways. And as I talk specifically through some of the findings and some of the questions we're struggling with, I want you to keep in mind the preliminary nature of this. One of the things, actually, what day is it? A few days from now, we will be in New York as a national team planning the next 2.5 years of this study. So when I ask, what do you think we should be studying beside this? I'm not like just blowing smoke. I actually, right, we are thinking hard about what to do next and what is missing here. Today I'm going to present the findings, spend some time on some of the theoretical and structural questions that I think underlie some of the phenomenons that we describe in the report. And I want to say that some of what I'm going to talk about was inspired by the reflection papers of the students. They asked some really hard questions, and I'm going to give it a shot to answer those questions as we speak. I'm going to talk a little bit about talking about race. There's some complicated race suggestions in some of this data, and I think we have to have a complicated conversation about that, so I'm going to end with that. The project of documenting what we call in this report pregnancy-related prosecutions has been a long and collective effort. The first effort starts in this 2013 publication by Lynn Paltrow and Jean Flavin. Lynn Paltrow founded what was then National Advocates for Pregnant Women and is today Pregnancy Justice. And that first report documents 413 cases. And Lynn started this organization in the early 2000s. She has led this fight for a very long time. She retired from Pregnancy Justice a couple of years ago now. But none of us would be doing any of this work without Lynn Paltrow. So that sort of starts there. After that, once Lynn told us what we should be focusing on, a whole bunch of other scholars and reporters started to look into this. This is Nina Martin's report. Can't remember when that was, in about 2012. And you see reporters, right? And this is, right, people have been working on documenting this phenomenon for quite a while. That's my book up in the corner, about 120 cases in Tennessee that I spent some time documenting. Grace Howard's book, which just came out, looking at South Carolina, Alabama, and Tennessee. And then a lot of that data ends up in the hands of Pregnancy Justice, and leading to their report just after a year after Dobbs, documenting prosecutions up to the moment of Dobbs. And then this study picks up at the moment of Dobbs, June 24th, 2022, and goes forward. So it's been this very long history of trying to document and understand a phenomenon that's, quite frankly, pretty hard to uncover because there is no national database where we can just put in a search and there they are. I wish my life would be a lot easier. So one of the things, I start talking and then I forget what I was going to say. So one of the things that became complicated, if you think about going from the second report to our report, is so after Dobbs, the crime of criminal abortion becomes something that exists and is implemented in this country in a way that it didn't exist before. So we use this term pregnancy criminalization quite broadly. But when we sat down to really think about what we wanted to say in the new report, we thought we needed a little bit more specificity in what we were talking about. So we have some definitions. So we call pregnancy criminalization something that occurs when the state wields a criminal law to render acts associated with pregnancy, pregnancy loss, birth, and or associated health care the subject of criminal prosecution. So if you think about that definition, that includes as yet unprosecuted criminal abortion crimes, right here in the state of Texas, right? We know of no healthcare provider who has actually been prosecuted, but certainly those laws and the potential for prosecution, as we all know, have had an enormous impact in a lot of ways that I'm not going to talk about, but I imagine you all know about. things, right? So pregnancy criminalization is the broad phenomenon of using criminal law in this way to target this conduct. Pregnancy-related prosecution, however, is a subset of that broader phenomenon. So one of the things we did is like, what's right, and the sort of unanswerable, but I can try, question of all of this is, what has Dobbs got to do with any of this, right? Because it's been happening for quite some time. So does Dobbs matter at all, right? And I have some thoughts about that, but that's one of those unknowable questions potentially. So a pregnancy-related prosecution, which is what we're studying in this report, is one in which the criminal charge is based on allegations related to pregnancy, pregnancy loss, or birth, and prosecutors argues that those allegations meet an element of a criminal offense. So these are actual prosecutions, right? Not theoretical criminal abortion prosecutions that could happen, right? And those, obviously those laws have enormous effect, but we're documenting actual prosecutions, and in fact, we're also documenting only prosecutions against a pregnant person in this case. So I'm gonna go through the findings a bit. So before I talk about the findings, I want to be really, really clear about both how we got this data and what the data is and isn't. So as I said, there is no database anywhere to find these. So we did things like media scrapes. If you guys talk to these guys, they were doing the Texas work, and they're literally going county by county. Christina's been very charming with clerks and really making friends wherever, right? But the amount of work it takes and the variability in systems, right? There are some states where we can ask for bulk data. There are other states where we literally have to go clerk by clerk to get this kind of data. And the data itself is sometimes police investigation files and court files. So one of the things that I emphasize in the report, or that we emphasize in the report, is that our report does not tell you what actually happened in any woman's life. What it tells you is what police and prosecutors say happened and what they think constitutes a crime. So that's really the focus of our research. And in social science terms, this is what we would call a convenience sample, which has a fancy definition, but basically means we found what we found. And it's therefore there are a lot of conclusions we cannot responsibly reach because we happen to find out about some cases, but there may be many, many others, and we think there are many, many others that we don't know. So this study, it's IRB approved, and here are, right, this is just that first year. So here's our big finding. In the year after Dobbs, prosecutors initiated at least, and at least is important because I think there are many more, 210 cases charging pregnant people with crimes related to pregnancy, pregnancy loss, or birth. This is the highest number of pregnancy-related prosecutions documented in a single year. I don't know if that means Dobbs made it right, more likely that these prosecutions would occur, and part of the reason I don't know that is we dumped a lot more resources into a much shorter period of time to attempt to document this. But nevertheless, it is 210 cases, and I will tell you that we closed the data set in the spring, and we are sitting on another about 260 cases in year 1 and year 2 that we have yet to code. So now I can say definitively this is the massive undercount. So 12 states are where we located prosecutions. And I'll talk a little bit more about some of the characteristics of these states, but the big three, Alabama, Oklahoma, where's Alabama? Why is it not showing up?
The dark blue.
The dark blue, there we go. Are some of the some of the states where there's a decision, also in South Carolina, that these prosecutions by the state Supreme Court, that these are lawful prosecutions, conceptualizing the fetus as a victim of these crimes. And those are issues that have been litigated over time. And I think, since I'm in Texas, I want to talk about the Texas numbers for a second, right? These guys can talk, and maybe we can do this in Q&A a little bit about how hard it was. And they only looked at how many counties?
That was only representative of a few counties.
And there are how many counties in Texas?
254.
Right. So this is not, right? Those are 6 prosecutions we found. We are quite convinced. And right, the relationship between the quality and access to the data of the data systems and the access to the data really affects, right, those kinds of numbers. Similarly, in Mississippi, it's really hard to look. In South Carolina, it's really, really hard to look, right? So these numbers are complicated to talk about for that reason. We coded the case files, and again, think about what we're looking at. Like, we're looking at police records, we're looking at bond forms and criminal complaints and, right, indigency applications. And so when you think about this data, we coded for low-income status. Our proxy was appointment of counsel, mostly. Sometimes in affidavits of indigency, they'll list income level or public benefits. But if you know anything about state standards for indigency, it's kind of all over the place. Some states have one definition. A lot of states are like whatever. Basically, if the person could afford a lawyer, right? These are not precise standards. Similarly with the race data, we'll talk a little bit about the trend line in the 3 reports on race. But race data in particular, with multiracial identity, with ethnicity, this data is really weak, right? I mean, multiple files, we'd have a different race indicator based on the piece of paper we were looking at. So take it with a grain of salt, but, and always when you're talking about race data from criminal data system sources, you're talking about weak data. So, types of charges. So it's helpful to understand this particular data point, to think about pregnancy-related prosecutions in 2 categories. The first category is criminal statutes that actually target on their face pregnancy-related conduct. Criminal abortion, feticide. In Tennessee for 2 years, fetal assault, which was explicitly about taking substances during pregnancy, constituting assault. Most of our pregnancy-related prosecutions are not in that category. Instead, most of the charges are generic criminal laws, most of them in the category of child abuse, neglect, or endangerment. So the conceptual model that this relies on, and I'll talk a little bit more about this later, is that it constitutes child abuse or child neglect or child endangerment if the pregnant person does something during her pregnancy and the victim of the crime is conceptualized as the fetus she is carrying. That is the legal theory on which they proceed for the vast majority, for 198 of these cases. Right? You don't get there if you don't think about it that way. So and that actually also goes back to how incredibly hard it is to do this research. Right? To figure this out, that means I have to pull every child neglect charge in the state of Texas, or they do, not me. Right, or whatever other state, and then go through, look at the allegations, and figure out if the allegations, right, are conceptualized in that way, are pregnancy related, and we're doing that kind of work, but it's hard. But that is how pregnancy related prosecutions work in the vast majority of cases. And but I want you to just like pause and think about that. Right? The pregnant person is a perpetrator in this theory, committing a crime against a crime victim inside her body, and her body is the crime scene. That's the concept, right? You have to accept all of that for this to work. So, we also, and this is, this is a little bit breaking my rule because mostly we were very strict about not believing facts just because they were asserted, but we did pull a couple of facts out of the allegations. And so we coded the files, which just means we went through and said, what we found inside of the files. We confused some people with thinking I was smarter than I am. They were talking about computer coding, and I had no idea what they were talking about. But we marked each file to figure out for these data points what existed. 144 of the 210 cases involved an allegation of a live birth and no subsequent fetal or infant demise in the case. So most of these cases, that's the scenario. In 22 of the cases, there was an allegation of a fetal or infant demise, plus some sort of pregnancy-related conduct that made them fit into our study. And these cases are horrible in different ways. The live birth cases are generally the child neglect cases, and they often involve family separation as a parallel family regulation proceeding where the child is being removed. They often involve jailing, a separation of that mother and infant. So these are really devastating cases in particular ways. They tend to concentrate in the South, in states where there are strong fetal personhood rulings and statutes. The 22 fetal and infant demise cases are a little bit different. Some of them are here. But that tends to be birth outside of a medical setting. It tends to be pretty emergent circumstances, miscarriages, stillbirths, and a set of allegations, and we'll talk a little bit more about allegations, but the descriptions are really quite horrific, women in, homeless women giving birth in a homeless camp, folks giving birth at home and outside of medical settings, and really sort of emergent circumstances. She's often alone, and it's a really, the facts are particularly horrific in a lot of these cases, and what the sort of conceptualization that, pregnancies end. They do, and we often don't know why, but the conceptualization that this was a crime that she committed during her pregnancy is particularly interesting in those cases, and then 44 where we don't know. So I don't know if we're going to talk a little bit more about this, but one of the things I really wanted to think about was what if police and prosecutors are thinking about pregnancy and acts associated with pregnancy outcome and birth as criminal behavior, what do they mean by that? What's the accusation? What are the facts alleged to satisfy the element of the crime in criminal law terms? So a lot of them, in 203 of the cases, the allegation is pregnancy and substance use, which is not surprising. That's been the case for a very long time. But then we have all kinds of other things going on, and some of which I'll talk about a little more later. But these are, I think we can think about these in terms of how stigma and criminal charges work together, So one of the ones we were really quite interested in was this allegation of lack of prenatal care, which is not a crime. It's not a crime not to get prenatal care so far. But, and one of the sort of crushing facts is most of these prosecutions take place in maternal care deserts, and yet her lack of prenatal care, or alleged lack of prenatal care, is posited by police and prosecution not as evidence of systemic failure, but as evidence of criminality. And I think that that's just something to spend some time But we were, the other, well, let's see, I'll do a little bit more about this. The other thing that, and this goes to the unanswerable Dobbs question, in 5 of the cases in the first year after Dobbs, in a pregnancy criminalization, in a pregnancy-related prosecution, there was some allegation having to do with abortion. Only one of the prosecutions was actually under an abortion statute, and in a now repealed provision of a state law allowing for the criminalization of self-managed abortion. But these were in child abuse allegations, in manslaughter allegations, in homicide allegations. But the fact of the relationship to abortion gets put in as that allegation. So at one point, in one of the cases, they said, well, she visited an abortion clinic. So she must have meant for this pregnancy to end. So that's evidence of her criminal intent, right? That she visited an abortion clinic. She had a pill, right? An abortion pill was on the evidence list in one of the cases. She obtained and consumed an abortion pill in an attempt to end or abort her fetus. Not, right? And then, screenshots, right? Going into her computer records, screenshot of a Planned Parenthood website, trying to research abortion. So, right, like, is it, how is Dobbs affecting this? I don't know. But this talk about abortion as criminal conduct, even in cases where the crime is not criminal abortion, is something that we saw and will continue to look for as we go. So I said 203 of them had an allegation of pregnancy as substance use. For those of you who are interested in drug policy, here are the alleged substances. And I'll talk about this a little bit at the end, but it is really interesting to me that methamphetamines are at the top of the list. That's not how it looked in the first report in 2005 or whenever that was, right? Like documenting prosecutions up to 2005, right? Cocaine was much higher on the list earlier in the history of pregnancy-related prosecutions, but now it's meth, followed by THC, and I guess one of the things I want to do is pause and say, I am not a medical, right? I don't do medical research. I don't take lightly any allegation, right? Like, I was one of those pregnant people who, like, tried to put myself in a bubble, right? Like, of course, right? Like, the science of this is complicated, and I think the results are complicated. What I do know, however, is that arrest and prosecution is not good for anybody's health. Right, so we can talk more about the data around the effect of substance use in pregnancy, and I'm happy to have that conversation to the extent that I can. But I think part of what comes up when people see this is like, oh, that must be awful. Maybe, maybe not. But even in those circumstances, right, she is more likely to want to seek care at this moment than any other. And if we turn it into a crime, she's likely to hide. And in fact, we had folks saying in the case to the police, I gave birth at home because I was scared I would get prosecuted. Candy Miller didn't go to the hospital because she was scared she was going to get prosecuted. Right? Not good for health. Speaking of, so one of the things, this was a very first year crim exercise that we engaged in. I was very curious because if you talk to prosecutors about this, they'll say oh, this is about the enormous risk to infants, and we really want to scare women into, right, carrot and stick. We'll get them into treatment. It's all about that. So we were like, okay. And so we took the list of statutes and we took all the elements of each charge and we put them in a spreadsheet to try to understand if they actually even had to prove harm in the cases, right? Is an element of the offense. All the law students, right? Everybody, right? That was, right? In 191 of the 220 charges in these 210 cases, the prosecutors did not have to prove harm, do not have to prove harm in order to convict. Unless you think that these are little charges, this is true about the 68 Oklahoma cases for which the sentencing range is 0 to life. It's true about the 103, I think, Alabama chemical endangerment charges under a provision of this statute, maximum sentence 10 years in prison. And lest you think that they would never do that, we pulled one of the Oklahoma cases recently. We didn't study the outcomes. It was a little early, and we had to get a report out, so we didn't go into outcomes. I looked at one of the Oklahoma cases the other day. She got a 20-year suspended sentence, 20 years on probation, which means she's going to serve. Nobody survives 20 years of probation, ever, right? So these are no joke. Finally, on data, we coded for the presence of family policing system. This is actually a massive undercount. This is not the kind of data that shows up in criminal systems, so we were curious what we could learn. So if she was if family policing agents were mentioned or they were like on the witness list, we would code for it, but that's actually probably a huge undercount. And then the fun thing we coded for was there information obtained or disclosed in a medical setting that showed up in the police and prosecution files? This is not evidence of who reported, right? We don't actually have that data for these cases. But if you think about that, so she's at the hospital, she's giving birth, she's signed some random consent form that allows you to do appropriate medical testing on her and her infant, or not. Or she makes a statement to a medical professional. I think we have all done this. I think it is fair to assume that that is for the purposes of our care. And yet, that shows up in a police report or on the basis of a criminal, right, as the basis for a criminal charge. So be careful what you tell doctors, I guess. So I'm going to take a little bit of time to talk about some theoretical constructs that I see at play. And some of this is in the report, some of it's what I'm thinking about, and it's stuff I'm going to be thinking about with this team for quite a long time. So I want to talk a little bit about, I'm going to go a little bit fast because I've been going for a while, fetal personhood. I'm going to talk about some of the allegations, thinking about conceptualizing pregnancy as a crime scene and Kara's criminality, and then we're going to talk a little bit about what's going on race in these cases. So, fetal personhood is the concept that embryos and fetuses have the same legal rights and protections as any person. This has been a decades-long strategy to instantiate this in our laws, and if you're interested in the legal sort of network of fetal personhood, Pregnancy Justice put out another report at the same time as ours. It's about 89 pages long. It's got like 400 footnotes. If you want to know what's going on with fetal personhood, I strongly urge you not to do your own research, but to just read that. But in our scenario, right, it's fetus as crime victim. That is the essential building block of the prosecutions. So, just a little bit, Oklahoma, Alabama, and South Carolina, where we find the most prosecutions, are the ones that have the state court decision saying you can bring those prosecutions. There's a case in Alabama called Ankrum, a couple more in Oklahoma and South Carolina that get us there. And this gives you just a little bit of the state of fetal personhood, but again, I would go read that report. So one of the many things that is bouncing around my head is this idea, like to pause and think about what it means to say that the pregnant body is a crime scene. So pregnancy and substance use is one allegation. I talked about lack of prenatal care, right? But if you think about the abortion related, like what does it mean to say that this is a crime scene? Right? How does that justify these prosecutions? Does that, I think we think a lot about this and other reproductive rights as diminishing the rights of the pregnant person. Like, if the fetus has rights, that just by the logic of the argument diminishes the rights of the pregnant person. But this is a very specific form of that diminishment of rights that I think is worth thinking about some more. I think that one of the things I'm thinking about is how does she, so in criminal abortion laws all over this country and in many other settings, the pregnant person is exempted from prosecution. So even in Texas, right? We can prosecute the doctors, we can prosecute the nurses, maybe we can prosecute mom who brings her to the hospital or whatever, but we can't prosecute the pregnant person. So why? It's just exempt under the law, I swear to God. So, but here, this is the pregnant person. So, how does she move from a person who is exempt from prosecution for, only political reasons, right? There's no logic to that, I guess, to being someone who we can conceptualize as subject to prosecution, right? What compromises her? What makes her vulnerable and not subject to that exemption? So it's just things I'm thinking about. But, right, these allegations, she was in a dangerous situation or dangerous location. That means she didn't go to the hospital, right? That means she gave birth at home or somewhere else. That's what's dangerous, right? Improper treatment of fetal remains, right? And I can't tell you, right? So there are cases in this study where she gives birth in this emergent circumstances. There's literally blood everywhere. She's sitting on the toilet because she doesn't, right? Because she feels like she has to go. The baby falls. She picks the baby up. She puts it down somewhere. That baby is not alive. Improper treatment of fetal remains. Right, all of the abortion allegations. So how does she become someone we can prosecute when on the face of the law there are exemptions? Just something I'm thinking about. Historically, this starts with basically in the 90s, in this idea that crack babies are going to be, right, this whole phrase, crack babies, this is, Lynn Paltrow called this the epidemic that wasn't, right? But the sort of the racialized tropes that give birth to this movement. There's a very bad story about science in this story, but this is a myth that gets debunked, but it's also a myth that gets weaponized by folks who want to instantiate fetal personhood early on. So it starts there, and we can see that. But to talk about the race data, so these are convenient sample, right? So we can only draw so many conclusions. Nevertheless, we have a trend, right? So in the first report, 52% of the folks that they found between Roe and 2005 are African American. If you look at the next two reports, the numbers become predominantly white folks. Disproportionality, we can talk about all of this, but there is a trend line there that I think we have to think about. So let's see if I can do this. One of the things I think, I don't know if you know this, let's see if I can make this go. So if you don't know about incarceration trends at Vera, you should, or not. Go back, advanced, let me in. Someone could be trying to impersonate. Accept, risk, and continue. There we go. So this is their institute. So this is jail incarceration by geography. This line is rural counties. So part of what I think is happening, and this is incarceration overall, part of what I think is happening that might, and this is areas for future study, is my guess, and we are looking right now and we will continue to look, are these rural prosecutions, and what does that have to do with the meth number, the race numbers? And then here's rural women. Trend line. Racial disparities. And then we can, I don't want to spend too much time on that, but some of what may be going on. The other thing worth considering is something Kiara Bridges calls path dependency. this idea that we build on a racist precedent, right? Like once we respond to cocaine use in the 80s and 90s as during pregnancy with a carceral precedent, then we just reinvent and continue to work on it. And then some scholars are thinking and have been thinking. There's a guy named Matt Ray who wrote a book called Not Quite White, which talks about the exclusion of degraded white bodies from ideals of whiteness and what that may have to do with this. Lots of things to think about. I also think that the fact that, right, meth is a white drug. I don't know if you all know this, but we all use illegal drugs at pretty much the same rate across race, across class, across geography. All of it, well, we differ on the drugs we use. So certain drugs, like our drug use, are very community specific, our drug use practices, but meth is a white drug, right? And the targeting of meth and the combination of white, right, this rise in rural prosecutions, this rise or incarcerations, I think that's some of what's going on. I'm going to continue to think about it, but I did want to float it since people ask questions about it. That's all I got for now. And now I'm going to take notes.
You're gonna take your pad.
Yeah, I'm going to take my.
Yeah. Great. Well, I want to thank Professor Engel for the invitation to join you all to engage with Professor Bach's work, and really want to thank Professor Bach for the incredible contributions of her research, both her contributions to sort of leading the study in the report that you have, but her whole body of work that's really been aiming to increase our collective understanding of the magnitude and nature of criminalization of pregnancy and reproduction. So I have about 10 minutes, I think, and I want to use my time first to say a little bit more about something that Professor Bach mentioned that's in the report, just about the difficulty and importance of doing the kind of empirical research on the criminal legal system that she has been doing and that this report represents, because I think the dynamics that make that work extremely difficult and important might be a little bit obscured to folks who are less familiar with the kind of mechanics and workings of the U.S. criminal legal systems. And then I want to offer a few points for discussion by Professor Bach, hopefully by all of us here. First, a couple observations and questions about the data and explanations that were offered for it in the report, some of which Professor Bach touched on, at least in part. And then I want to think a little bit together about the whole kind of post-Dobbs framing of the study and of conversations around criminalization of pregnancy and reproduction more generally. And then lastly, if I have time, if not, I'll pocket it for questions later, but maybe an observation about the study and Professor Bach's earlier work also as kind of a cautionary tale in some ways for, or at least presenting some cautionary notes for abolition or soft abolition, conversations about shifting resources out of the criminal legal system and into sort of care systems. Okay, so first, a bit on the difficulty and importance of the showing work here. So the report touches on this in the methods section, but sometimes that gets short shrift in the reading. And so I just want to lift it up because here it's really, really important. One of the signature features of the administration of American criminal law, signature in terms of understanding it and signature in terms of distinguishing it from many, 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 many other systems around the world, is the stunning degree of fragmentation of that system or of those systems, right? So just the content of criminal law, right, is written by more than 52 entities in the United States, and that's just counting the federal system, states, the District of Columbia, because those are all the legislatures that are writing all these different criminal laws all on their own. They all just get their own ideas and write them down. They're all different every place, right? But that's a dramatic understatement because lots of localities, too, have the power to write and enact at least some forms of criminal law. And in fact, not so much maybe in the criminal legal space, but we've seen this already here in Texas in the abortion context with some cities, right, enacting their own laws restricting travel through the cities to get out of the state of Texas, right, to go someplace else to get an abortion. So there's lots of law going on in terms of, including lots and lots of criminal law, right? But then criminal law is enforced by far, far, far more independent kind of bureaucracies, right? So in most jurisdictions, investigation and prosecution and adjudication of crime is done at the county level, right? So that's Professor Bach's allusion to getting a handle on what's going on in Texas. That's 254 separate criminal legal systems with 254 separate sort of elected decision makers about charging, and many, many, many more separate investigative agencies making decisions about whether to investigate particular crimes, and many, many more judges located within those individual counties, many of whom have their own sort of practices with regard to bail, many of whom are keeping their own records about what's going on in particular cases, right? And then further, right, the vast, vast majority of data about all of this that's going on, right, is never sort of pushed out in any public form. It varies even in how well it's collected, but it's rarely actually sort of distributed, right? So we here in law school learn how to learn the law through cases, through judicial work product, right? But the vast majority of what starts and ends as a criminal case is never documented in a judge's opinion. They mostly end in dismissals or unappealable guilty pleas. So to figure out what was ever happening, you have to like truck over to the courts and literally, knock on people's offices and say, show me, your records from this period of time, right? But then, of course, there's no standard reporting from place to place on the content of what cases are being charged and prosecuted. And there's definitely no sense within the criminal legal system that they should write down and count the kinds of things that maybe we actually care about knowing, right? Like, well, how hard is it going to be to figure out whether the victim is a fetus or someone born alive, right? The system isn't keeping track of that for us easily, right? So, and then lastly, right, the phenomenon that Professor Bach and her co-researchers are trying to study really defies easy categorization, because once fetal personhood is on the table, there's little end to the potential universe of crimes that could be committed against a fetus. Right? So this is not just a matter of kind of running queries for particular crimes. It's an incredibly labor-intensive and creative sort of sleuthing job that requires basically needle in a haystack level researching. And so the difficulty and the importance of undertaking this work really can't be overstated, right? And frankly, one of the independent contributions, and Wendy and I were talking about this earlier, one of the independent contributions of this kind of work is to help other people learn how to figure out what is going on in the criminal legal system, which is just something that we don't actually have a lot of kind of collective knowledge about, sort of systematized knowledge about how to do this research. So we're better off in all sorts of ways for Professor Bach and her team for doing this work. Okay. Second point, the challenges that I just described make this work particularly valuable. Also, as Professor Bach already said, and as the report makes clear, it places some limits on how confident we can be that when we do empirical work on the criminal legal system, the snapshots that we're able to get are complete or representative, or on how well we can test explanations that we might posit for what we see. And again, the report, I think, is extremely transparent and cautious about the extent to which conclusions can be drawn or assumptions can be made about completeness, right? That said, I wanted to isolate two aspects of the findings to invite some further reflection about representativeness and maybe what future iterations of the project might dig into. So one is about the locations of these prosecutions, right? So the data reveals this extremely concentrated and like bimodality, right, in the prevalence of these prosecutions in the states. So they've been found in a small number of jurisdictions, with most of the ones that have been found clustered in single digits in the jurisdictions, and then two, right, Oklahoma and Alabama, like way out there, significantly outpacing the rest. And the question is, what are we to make of this, right? So on the one hand, just consistent with other facts about those states, about Oklahoma's and Alabama's sort of punitive legal culture. They're both states with total abortion bans. As Professor Bach offered, they're both states that have state Supreme Courts that have weighed in on the fetal personhood idea. But still, what explains significant differences with neighboring and like seemingly comparable states, right? Texas and Florida, for example, right? Just south of Oklahoma, just east of Alabama, quite comparable in terms of criminal legal culture, quite comparable in terms of the law, including on fetal personhood. So what explains the sort of absence of documented instances of some of these cases? It would be interesting to dig into the data, right, to try to get more granular to figure out what some salient differences might be, in part to understand drivers and to perhaps start to be able to predict some inflection points, right? Right, one question that comes to my mind is, to what extent in these states with big numbers are the prosecutions still concentrated in particular counties? Or are these jurisdictions that have managed to kind of get many prosecutors on board with this project? And maybe that's driven by clarity from the state Supreme Court, right? But knowing more about the distribution among counties, right? Knowing more about some granular differences in positive law. So Professor Bach mentioned what state Supreme Courts have said about fetal personhood. Another possibility that came to mind, though, later in the presentation was what states have enacted laws that criminalize risk without requiring proof of harm and subject that conduct to very, very high sentences, right? Enabling, basically handing prosecutors a tool to more easily sort of win convictions without having to prove an element, right? And with significant leverage, maybe for generating pleas. There are lots of other possibilities here, but just thinking about some granularity in comparing states, I think would be important, and I'm sure that they're contemplating that. Okay, I had a second point about the data with regard to race, and I think that I'm going to actually put that to the side because Professor Bach's already touched on it. I'm running out of time, and I think there will probably be more questions about it in the Q&A. So let me go to the point about Dobbs and post-Dobbs as the framing for the report. Okay, so the simple and obvious observation here, right, is that centering Dobbs as the jumping off point for the study introduces what ends up being, once we see what the study reveals, like a little bit of misdirection, right? Because yes, Dobbs dramatically shifts the constitutional landscape and paves the way for recriminalization of abortion and maybe more, but the report's key findings are really more like the more things change, the more they stay the same, right? So yes, there's a year-to-year increase in these prosecutions, but the people, maybe, they're seeing a year-to-year increase in the prosecutions, right? But the people being charged and the conduct being criminalized and the charges being brought are essentially identical to the people being charged and the conduct being criminalized and the charges being brought when abortion was constitutionally protected, and all those reports that Professor Bach gave us the pictures of beforehand, right? And as the report notes, and as Professor Bach concedes, there are decent reasons to think that the numerical increase might actually be a product of visibility and effort rather than changed practices, right? So I worry a little bit, and I strongly suspect that Professor Bach worries about this too, so this is not a challenge, but rather an invitation for her to discuss this more here, that continuing to focus on Dobbs as a kind of turning point, but then like failing to show receipts for actual abortion prosecution, right, could be a missed opportunity, and in particular a missed opportunity to teach non-marginalized people who just want access to their abortion pills and otherwise live their lives kind of beyond the grip of the state, that their fates are really bound up with the fates of the drug-addicted poor women who've been invisibly punished and separated from their children all along, right? And to some degree, their fates are, in fact, bound up together as a practical matter, right? Because states might begin to follow the example of Louisiana and just schedule abortion medication, right, as a drug that's prohibited just like methamphetamine or anything else on that list, right? At which point the statutory tools for criminalization are exactly the same. Techniques for surveillance, right, for at least motivated actors, techniques of digital surveillance in particular, right, are likely to be the same. The lever of fetal personhood, once pulled, threatens the autonomy of everyone who can be pregnant, right? Everyone's bodies can be a crime scene under that concept. But, on the other hand, the disproportionality of the risk to prosecution for folks who are already marginal in society is so much greater in degree to really probably be different in kind. Right? It is just so much less realistic for people with means who are not already kind of within the grip of state surveillance in some degree to live fairly confident, right? That this kind of stuff is not coming from them, and so coming for them. And so it seems to me that maybe the more important move is to construct something like a moral case for these fates to be bound together. Right? Because the practical case might never really persuade as a realistic possibility. So I wonder what Professor Bach thinks about that. I wonder what work is required, right, to build a coalition that cares as much about the reality of prosecution of drug-addicted, poor, pregnant people as the specter of prosecution of doctors and mobile middle-class folks. And one thought that I have as a practical matter is it may be that there's a connection there to further strands of research, right? To maybe attempt to pull out some of those very features that there's no reason really to think that they would be isolated to just prosecuting neglect or isolated to just prosecuting the types of charges that we're seeing there, right? So identifying instances or the prevalence of digital surveillance, for example, right? Yeah, so interesting. So maybe then we're just back to...
How many times I've been asked that question?
Yeah.
1,000. Yeah, it's not there.
Yeah. Because look, they don't need to. Right, that's the thing. It's difficult, it's expensive. Right, if you just ask the doctor, you can just ask the social worker, like, what's going on. You don't need all that expensive and complicated stuff. And so there's so much low-hanging fruit to prosecute, right? All right. That would segue to my point about shifting to care systems and the entanglement of those care systems with this, and whether a shift there is really going to help at this point. But I'll leave that to the side because I've already gone on for too long. So bottom line, thank you so much for this work, Professor Bach, and I look forward to the conversation.
We've got half an hour. Is that right? Till 5:30? Is that what? Yeah. Okay. Should I respond? Should I take other questions? What do you want me to do? I can do a quick response to some of it. First of all, thank you. Yes, I am worried about all those things. all my time worrying about all those things. The locations is a really complicated question that I'm struggling with. I'm not going to respond to that one because I actually want to go to the Dobbs one. Yeah, I don't know what I think about this, but I'll share some preliminary thoughts. So I was joking with the students yesterday that I wrote a book that came out in 2022 before Dobbs about pregnancy criminalization in Tennessee, and I got, I don't know, like 4 press mentions. I mean, and part of this was communication strategy and pregnancy justice, but I co-authored with this amazing team a report about pregnancy criminalization post-Dobbs, and we got 450 press mentions. So, and as I was describing to some of the students, you know, it took me a lot of time, and everyone who talked to reporters, I think Blake talked to reporters too, right? Like, the first 15 minutes of every conversation was about abortion, and the 5 cases where abortion was mentioned. But a lot of times, I got them to focus on something else. So in some ways, the decision to call this post-Dobbs is a political decision and not a right, and I don't mean theoretical in a light way, but in a, right, like from a sort of my theoretical consistency hat, I'm uncomfortable with it. From my political hat and the experience I just had, people are listening because it's post-Dobbs. And frankly, we got $2.1 million to do it because it's post-Dobbs, right? So the politics of this and the reason people are listening is because of Dobbs. I don't know what to do with that. I don't disagree with anything you just said, but like that has been the reality of my life for the last, I don't even know what month it is, right? 2 months. But I think that I want people to see, you know, one of the, Madeline Wasilchik and I have been joking about article titles. Like, we keep on talking about all the things we're going to write when we finally stop doing this research, which is like never. But one of the titles we are playing with is "They're Coming for You Next," right? Like, I do really believe that, and how to make that case, like how for folks to see that all of us are bound up together in this, that the fate of one is really, truly, in this circumstance, right, the risk. I think that's right. How to tell that story in a way that is consistent with the data, that is consistent with the way I want to tell the stories of the folks who are prosecuted and the way their stories get told in the data, is complicated, right? It's really complicated, but yes, thank you. I mean, you're pushing me to think for it more. Yeah, and I knew what you were going to say about care, and I totally agree with everything you were going to say about care. I was looking at some of your work. I don't know, she could talk for herself, but like, you know, medicalizing this is not, right? Like, when people ask me, what's one thing you would do to radically change this circumstance? And I say child tax credit. People are like, what? And I'm like, people, you know what makes life better? Money. Money without strings, money without surveillance, money without, right? Like, when people have more resources, right? You know, I love the guaranteed basic income research coming out. I'm completely obsessed with this data because, you know what gets better? Everything. Everything gets better when you're not working 3 jobs. And do you know what parents do when they have a little bit more resources? They spend time with their kids because they're parents. Right? Like, they're not like evil demons who hate their children and want to harm them, right? Poor people are just people, and most people want to spend time, right? It's just, the data is so simple and straightforward, and that's a sort of, right? So I agree with what I think you were going to say, and I was thinking about it because I knew you were going to comment, but, right, like, medicalizing this is not the answer, but some of these are medical problems, right? So, for what I will say about care systems versus punishment systems is that some folks need care. The folks we are talking about there's some really wonderful work about there. When you are suffering from substance use disorder, pregnancy is a moment when you are most likely to seek and be willing to go through the very difficult journey of addiction treatment. So, you know, every doc I talk to who does this work well says, you know, you respond to that moment with an offer of care. right? But when you start talking about sort of poverty and addiction and deaths of despair and all those kinds of things, it's about money and poverty in a lot of ways. So that's what I could say more, but other questions, or who's doing this?
So we'll do the students are well aware of our 1 and 2 categories, but for everyone else, if you have a question, you can raise your hand and give a 1. If you want to respond to somebody or follow up to someone else's question, a 2. We're going to start with the students first. We have about 20 minutes for questions, and we'll keep a list of your names. So students, y'all, and also if you asked a question at lunch because you feel like it's important, feel free to ask it again so everyone
Absolutely.
can the answer. Nancy?
I'll try to
Is
get
that a
this
hand?
Is it a 1 or a 2?
Well, kind of a 2 based on what you just said about kind of medical systems or care systems. So thinking about the body as a crime scene, I'm having a really hard time sitting with that, just because coming from like a nursing perspective, like all of my education has been around like providing care.
Yeah.
And so that's been turned into surveillance. I'm just having a really tough time with that. So I guess my question is like, is there work being done around trying to kind of tease that out and sort of change that perspective back into care and not thinking about the body as a crime scene?
Well, yes, so there's pieces that come to mind, so thank you for the question. Yeah, no, the reason I talk about it is because it's both a very accurate description of what is the conceptual framework, and it's really uncomfortable to think about that. So I'm sorry, but yes. But look, this data is not about who refers out, but it is very clear that healthcare providers are the major source of family regulation referrals in the 0 to 1 category, and it has been growing exponentially. If you want to stop pregnancy-related prosecutions, you have to choke off the information flow. So enhanced, and we can talk about HIPAA, but like enhanced healthcare privacy, informed consent for drug testing for pregnant people. But really, like, we need HIPAA's a terribly weak law when it comes to this stuff. There's all kinds of exceptions that we could talk about. So you really have to, I think from a legal, like we're sitting in a law school, that's the legal response. A lot of people who work in this field, and people who are adjacent to this team do a lot of work around educating healthcare providers. I love, when I was writing the Tennessee book, I had a student who was a law student who was a former actually she was still doing labor and delivery work for money during law school, and she volunteered to be on the research team, or she applied, and I was like, please God, yes, right? Like someone who actually understands this setting. So I asked her to mark or code the files for presence of information obtained or disclosed in a medical setting, and she went off with 50 of the files, and I asked her to come back. 3 days later, she walked into my office crying because she had told people that what they told her was private. And then she saw, and she had actually been involved in some of the cases, which was the source of the tears, understandably. But like, there's interesting work to be done, and there's some interesting work being done about how healthcare providers view this. And I will say, as to nurses in particular, since you are one, I have seen an infant withdrawing. It's terrible. It's terrible. It's an awful thing. And if you're a labor and delivery nurse and you don't see what comes before, you don't see what comes after, and you see that a lot, I actually have some sympathy for feeling like you have to do something. So helping healthcare providers understand that the do something is a harmful something is I think, real work. I don't think that this is like, I don't describe to like evil beings who do evil things, right? I think we have a lot of bias, and people sit where they sit. So educating healthcare providers is part of what I think we have to do.
Marisol?
Hi again, Professor
Hi.
Bach. Thank you for your talk. So my question is about, you mentioned during lunch and sort of alluded to during your talk that you were interested in further studying the outcomes of probation in
Yeah,
particular in
yeah.
these cases.
Yeah.
And so I was wondering if you could speak more about why that's a particular interest and what you might hope to draw out from further study.
Yeah. So this goes on the list of 4,000 research questions we may follow up on in the next 2.5 years. So we're going to have to make some hard decisions. But a lot of folks right, like mentioned the woman in Oklahoma who got a 20-year probationary sentence, right? So for those of you who don't speak crim, right, that means her actual sentencing document says you were going to be incarcerated for 20 years, but the judge has discretion under that statute to suspend it to probation. Then you have to follow lots and lots of rules for 20 years. And if at any moment the judge decides that you have violated a rule of probation, which are long and extensive, and by the way, you're paying, $50 a week or whatever you're paying for the great privilege of being supervised by the state of Oklahoma, plus you're probably paying for the ankle monitor you're wearing and the drug tests they're doing and so on and so forth. We could talk about that. But so I think, and this is a piece of criminal law, empirical criminal system scholarship that I'm interested in, right? That sounds like probation, no big deal, community supervision, right? So I think part of one of the reasons I think this might be an important question is, when I think about research questions, I think about if we know and can describe this better, will it move the needle? Will it change hearts and minds? That's what I really want to know. And I think people think probation's no big deal. And having represented people on probation is a very big deal, right? And my guess, if we follow 50 women who get probationary sentences, is well over 50% of them will end up serving. So I think that's a story worth attempting to document. Maybe, of the 45 others.
Celine?
Just going back earlier to what you were saying about you don't believe that it's evil people doing evil things, or I guess reading the report and thinking about the data about most of the prosecutions not needing to prove that there was harm to the fetus, and so that kind of maybe cuts against the idea that this is about protecting the fetus or protecting unborn children, or however you want to put it. I guess reading the report, it kind of gives you the idea this is just about punishing pregnant people. But then I guess I'm wondering how you would put this sort of motivation, because then it seems to sort of not square with it's hard to think how somebody might.
So I think that there's a couple ways to look. When I say I'm not interested in evil motives, I'm not interested in ascribing evil motives to the human who is making a decision at any particular point. I don't know that that's useful for me as a scholar to be doing. But I also think that the way we set up our systems, the way we act as a society, does reveal how we want things to be. I don't think things are the way they are just 'cause. I think, and if you look systemically, so, right, I think that we can say, based on the data, that for what we know about these cases, it is about controlling and punishing pregnant folks. I believe that to be true. I'm not so interested in being you prosecutor, right, hate poor women, right? I don't know that I may think that personally, but I don't know that that's a helpful, right? I'd rather think about it differently. That may just be how I survive doing this work, but to me, it's the same thing, you were just saying about, right? There's we could design criminal systems where the data is transparent, where we wouldn't need $2 million and 4,000 people to figure this out, right? But we don't. And that would indicate, as a society, that we don't particularly want folks to know what's going on, right? So.
We're going to open it up, so if anyone else has questions. 1, 2, Sydney.
Are you Sydney who wrote the paper?
Yes.
It was great. Thank you.
Thank you so much for being here. It's been really interesting reading your paper and listening to you speak about it. During your presentation, I just started thinking about the sort of scary things that have been happening in regards to IVF.
Yeah.
And the legal status of embryos. And I'm just kind of curious what you think about that, and if you think that kind of fits into this idea of pregnancy criminalization, and if you expect that to become more common throughout the study.
Do I think they're going to criminalize IVF? Is that what you're asking me? Good God. What day of the week is it? Ask me in a week. No. I don't know that. I think no. I think exemptions for the pregnant person for criminal abortion will fall before IVF, right? Like, who gets IVF? Right? Rich people, white people, right? Yeah. I think that there's a political, I think there's a political line that I think that would be just politically disastrous. I think that somewhere the exemption for pregnant people for abortion will fall. Maybe. I think it really depends. God. A person who can think more dark thoughts than I can, that was impressive. You seem like a nice person. But I don't know, Blake. Criminalization of IVF, what do you think? No, yeah. What else? It's late. You can ask more questions.
Okay, also about the slide about the most of the statutes that they were being prosecuted under were not requiring proving harm to the fetus. Were they mostly or all just like what did they have to prove? What is it, just like that the person
Pregnancy and substance use during that pregnancy. So a positive tox screen and the fact that she was pregnant. Not super hard to prove, right? Maybe a confirmatory drug test if they were thinking crazy. Yeah, almost nothing. Almost nothing. Yeah.
Sorry, thanks. I was wondering, so, when you look at a lot of these statutes, and we kind of had a discussion around, when legislators are writing these statutes, is the intent behind them, was it originally to control and protect women with maybe a child neglect statute, or is this being implemented in such a way, or is there prosecutorial discretion that is making it now so harmful? And I'm just kind of wondering this question of intent versus implementation, and how do you fix that problem? Is that a problem for the legislature? Is that a prosecutorial discretion problem? Where is the crack in the system? Is it from the very beginning? Is it when it's being implemented?
So it depends which statute you're talking about, as Professor Lauren was explaining. There's, there are, I don't know how many statutes on our spreadsheet, like 80, I don't even remember. So you can only talk about one statute at a time. But for example, the Alabama cases were all brought under chemical endangerment. And the reason I can say that, that's actually what we looked for. There may be other Alabama cases. That law, if you look at the legislative history, was originally focused on cooking meth, right? Cooking meth in the presence of children. That's what that law was for. And then some creative prosecutor decided to conceptualize the fetus as a victim of that crime, and they brought that prosecution, and it went up on appeal, and the Alabama Supreme Court in 2013, in Ankrum, I believe was the name of the case, said, works for me. So you tell me, right? If we can get the Alabama legislature to change their mind, that would be awesome. I don't think that's going to happen real soon, right? So, Karen. Oh.
Are we really sure nobody? Well, there's an awful lot here, and it's amazing. You presented it so clearly, and then there are more questions even.
I know.
But I wanted to go back to the exemption of the pregnant person.
Yeah.
And I wonder if you could say in how many of these states or under how many statutes the pregnant person should have been exempted.
I don't know.
And there was a prosecution anyway. Which we know
I don't know the
happens
answer
in
to that
Texas,
question.
just to
We
be
know
clear.
that happened in Texas, so in some of the Texas prosecutions. But I actually don't know the answer to that. And it's actually, we haven't actually looked.
Wouldn't that be
Yeah.
good?
Yeah,
The next
let's put
step?
that.
I
Yeah,
mean-
someone say that on Saturday. Saturday is our all-day retreat on what research questions we're gonna do. Yeah, no, that'd be cool. That'd be cool.
Because it would get.
Does it move the needle? That's gonna be my question all day Saturday. Will it move the needle if we spend our resources? And I'm not saying it doesn't, but like our job as a team is to decide which research questions are the most important, because it is endlessly macabre-like fascinating to talk about this. But that's all I'm going to say all day on Saturday, is if we spend some of this money and some of this time and some of these humans' time on that question, will we learn something that changes the conversation? And I think that maybe yes. But yeah, that's what we're going to have to figure out. Although maybe I'll just do this forever and just ask more and more questions. Yeah.
Thank you for such a great presentation. I have more of a theoretical question. So when it comes to the prosecution, you're able, in the state right now, you can prosecute the pregnant person, the doctor, somebody who
Wait, are we talking about abortion? What are we talking about?
abortion, or in the other?
So you cannot prosecute the pregnant person who got the abortion.
Okay.
She's exempt.
Is there any theoretical possibility of researching prosecuting the person who got the person pregnant? Has there been any history of that?
What did he do that constitutes an element of a criminal offense?
What did they do that prosecuted?
I mean, if you talk to these prosecutors, they took the drugs. They didn't get prenatal care. They had the audacity to give birth at home. Right? Obviously not what I think. Maybe he's at fault for giving her the drugs, right? There's actually some creepy little prosecutions out there. There are some disturbing prosecutions where, a guy slips her mifepristone, which is, and he did in fact get prosecuted for that. But that's the only one I can think of. But yeah, he'd have to do something. But yeah, no, we're thinking about. I don't know.
Yes, hi. So my question is, do you think that these prosecutions and the lawmakers making these prosecutions possible are actually motivated by a good faith belief in this concept of fetal personhood and that they're actually protecting life? Or do you think it's more about just another way to police marginalized people? Or it could be both, I don't know.
Can I say you'd have to ask them? What do I think? I don't know. I really, really don't know. Maybe we'll put that in the qual bucket, right? Yeah, I don't know. I think it's hard to answer. I don't think simplification is going to help us here, right? I think it's both. I do actually think it's both. And I was thinking about, and I don't know if this answers your question, I think that there is harm we're willing to see and harm we're not willing to see, right? And I think about this not so much here maybe, but in family separation, in the family regulation context. We can see this alleged harm of the abuse, the neglect, right? But we refuse to see, I always say to my students, hypothesis, do you think the state's a really awesome parent? That's an absurd thought. And in fact, we know that the state is a horrific parent, right? That is extraordinary. But we see and are willing to conceptualize some harm and conceptualize the perpetrators of that harm in one way in order to constitute that as harmful. But we invisibilize straight harm and harm by privileged actors. So it's complicated.
Yeah, going to the race of it all, the race statistics.
Oh, good. Let's end there. Awesome.
Just a quick question before I ask my question. So the states that weren't mentioned, like New York or California, was it because data wasn't mined there?
There is a California case.
Oh, sorry.
There is, but anyway, go ahead.
Was it because data wasn't mined there, or a preliminary sweep of the statutes was oh?
So most of what we know I mean, it's a big fat mess, right? How we were collecting data. And we're going to do a little better. We're never going to do as well as we wish we could do because of all the things about the data. But a lot of these were media scrapes. So we found out about it because the press reported it. The problem with relying on media scrapes is that the media tends to report the fetal demise cases, right? Like the big cases, right? The cases that, like, nobody's going to report the 75th chemical endangerment charge in whatever county in Alabama, right? No, that's not press-worthy. So that's part of what skews it. Some of, and part of where we looked, and we're actually thinking about this more systematically going forward, but part of where we looked is where we knew what was happening. So we invested a lot of resources in Alabama because it's been a trend, right?
So
your question.
Yeah, with that, and you've definitely accounted for this, but with the overwhelming white criminalizations, and those theories were explanatory of maybe why this trend is happening, like the rise of rural incarceration, but can we say that we're certain about that with any sense of certainty? Because okay, that's what I thought, because a different sample.
Well, I will say there's one state and a few counties where we know this is a denominator problem. Like, if we don't know what the full set is, we can't do any further, right? Like, there's nothing else you can do with a convenience sample, right? But in Alabama, and we just haven't run the numbers, but we're actually looking right now at geography and at race in Alabama, and trying to tease this out. But we just hadn't done it for this report. So there will be places where we can ask second order questions. We will never get fully past the convenience sample. So we'll never be able to say, as a nation, it's disproportionately this or that. But in certain geographic areas where the data systems are good enough that we can reliably say we found every case or a reliable sample of every case, then we can start to ask those questions. But now, nope.